Several new developments in the search for missing Union High School football coach Travis Turner. Virginia State Police announced today they have issued 10 warrants against him. It's our top story tonight. Good evening. I'm Sarah Diamond.
And I'm Casey Marler. Turner now considered a fugitive. He was last seen Thursday. Then agents with state police went to his home as part of an investigation. While on the way, police said agents were told he was not there.
Well, now Turner is wanted on 5 counts of possession of child pornography and 5 counts of using a computer to solicit a minor. We've since received statements from Wise County Public Schools, Virginia State Police, and an attorney for the Turner family.
Questions have been raised regarding the process for releasing new information, as well as what is delayed from being released.
News Channel 11's Haley Pitcher takes a deep dive into what schools and law enforcement are and are not compelled to reveal to the public. Haley?
Thanks, Sarah. The search for Turner has left the community with many questions. Now, these answers may not be as simple as a public records request. I spoke with a Virginia attorney to define what matters in the case can be relayed to the public and where law enforcement and the school system can, for now, stay silent. The warrants regarding Turner are not required to be physically released due to an ongoing investigation. Former Commonwealth's attorney for Wise County, Chuck Slemp, says warrants can only be issued due to probable cause, as required by the Fourth Amendment.
Law enforcement has an opportunity to pursue criminal charges by taking the facts of the particular charge to a magistrate. And that magistrate will consider whether there are sufficient facts to issue a warrant for someone's arrest, and the sufficient facts would be proven by probable cause that a crime happened.
In Virginia, law enforcement is allowed to reveal as much or as little as they want regarding an active investigation. Slemp says documents from an active investigation are not considered public records and cannot be requested for release until the case's conclusion.
Under the Virginia Freedom of Information Act, we prioritize the public release of information to the broadest extent possible, while also protecting the integrity of police investigations and prosecutions. And so what I mean by that is, under Virginia law, law enforcement active investigations are exempt from release under FOIA.
School systems in Virginia are subject to the Freedom of Information Act, but personnel matters are exempt. Slemp explains a personnel file includes pay stubs, length of employment, and even an individual's name.
Public records about someone's hiring date and firing date and any disciplinary actions or anything of that nature can be shielded from public release. Not can be, they must be shielded from public release because it is exempt from FOIA. And that's because the employee has a privacy concern.
Slemp adds these factors are all in place to balance public information with a fair trial.
We're in the information age and everybody expects to be able to know everything going on right now. Transparency is important, but so is preserving the integrity of a criminal case.
And Slemp also adds ongoing investigations involving personnel matters must also balance the public's right to know and an individual's right to privacy. Additionally, being named a fugitive does not change any matter related to an individual's privacy. Back to the desk.